During the debates about the inclusion of an indigenous voice in the Constitution, I heard a lot about the possibility of amending the preamble or even of creating a whole new one that could then recognize Indigenous Australians without changing the dynamics of the Constitution too much. In one of my first videos in this channel, I talked about the nature of the preamble and what function it has in constitutional interpretation. A large part of scholars considers the preamble as having a meta-constitutional nature. That is, it is not part of the Constitution. It is not constitutional per se, but it helps us to interpret the constitutional provisions better. It provides us with the historical context to better extract the meaning and intention of the constitutional text. So the preamble is not formally part of the Constitution, but it can be a helpful tool to understand the Constitution itself. This is the view that I hold. So in my last video, we talked about Section 5138 and how the Australia Act was enacted according to that section. In the end of the video, I asked whether it would be possible, for example, to amend the covering clauses of the Constitution Act or even the preamble to the Constitution using Section 5138 as the constitutional basis for the change. So now is the time to bring all of this together. Hello everyone, my name is Renato Costa, this is Aussie Law, and today we'll talk about the possibility of amending the covering clauses of the Constitution Act and changing the preamble to the Australian Constitution. Most constitutions have a preamble. Some include them before the title Constitution, others call it by a different name like Introduction. Some are rather small, others quite long. But the fact is that preambles are a common practice. When it comes to the preamble to the Australian Constitution, however, we must be careful not to rush too much to conclusions. Because the first issue that we face is with the location of the preamble. You should remember that there is a difference between the Constitution Act and the Constitution itself. The Commonwealth of Australia Constitution Act, enacted by the UK Parliament, contains the Australian Constitution in its Section 9. The Act itself has some covering clauses and it also has a preamble. The preamble to the Act is normally what we refer to as the preamble to the Australian Constitution. But strictly speaking, the Australian Constitution does not have a preamble. So let's start with this point. Is it even possible to create a new preamble? Broadly speaking, I think it's possible. I have some doubts whether we can do it in Australia, and you'll soon understand why, but for now, let's just go with this broad assumption that it could be done. It could be possible to create a preamble to the Australian Constitution rather than just having one for the Constitution Act. And let's take the 1999 preamble referendum as an example. In 1999, with the Republic referendum, there was also a proposal to include a new preamble in the Constitution. And certainly, after the Voice referendum from 2023, a lot of people have been talking about the possibility of creating a preamble to recognize Indigenous Australians too. Now, one aspect of that proposal from 1999 was that the preamble that would be inserted could not be used to inform constitutional interpretation. The text of the proposal literally said that if the preamble was approved, a new section would be included in the Constitution, Section 125A, that would say that the preamble has no legal force and shall not be considered interpreting this Constitution or the law in force in the Commonwealth or any part of the Commonwealth. Well, of course not. The preamble is not constitutional. It has no constitutional material. It is a statement of fact about historical circumstances and the making of the Constitution itself. It is, as I said before, meta-constitutional. So, in my opinion, and from my point of view, I see little relevance in creating the preamble. Although I think it is apparently possible, it sounds like a waste of time, resources, and effort. The preamble is a declaration. It has a symbolic function, that's true, and it can be effective in that respect. But the preamble will not change how the Constitution is interpreted, how it must operate, or how it affects people's lives. The preamble has a historical function rather than a constitutional or prescriptive force. But you could then ask me, what if the preamble could have interpretive force? Would that change anything? Well, my answer would be then this is not a change of the preamble. It's a constitutional change. Since the preamble is not part of the Constitution, it doesn't make sense to propose a constitutional change through the preamble. Honestly, that sounds dodgy. But another question could be raised though, and I think this is a better one. Can we change or create the preamble using the provisions that exist in the Constitution? Can we adopt the process of Section 128 to create or alter the preamble? As I mentioned, this was already attempted in 1999, but I'll be honest here and say that I strongly disagree with what happened. So my answer to that question, whether we can change the preamble through constitutional mechanisms, would be no. I don't think we can use Section 128 to change or create a preamble. This makes me part of a group that has been called the Orthodox view. I have two reasons for joining this group though. The first is based on the meta-constitutional nature of the preamble, and the other on the text of Section 128. So first, it is not characteristic of the preamble to change the Constitution. The preamble being outside the Constitution is not subjected to the constitutional processes for the alteration of the Constitution. In fact, if you read the very first words of Section 128, it says, "This Constitution shall not be altered except in the following manner." The Orthodox view then defends that the text of Section 128 restricts the process for the alteration of this Constitution, but the preamble is part of the Constitution Act, not of the Constitution itself. And again, although I am being a bit repetitive, we must remember that the preamble has no constitutional force. As a statement of fact, it contains historical references that can help us understand the Constitution, but it is incapable of altering our constitutional interpretation. The preamble is not constitutional, and Section 128 is used only to alter that which is part of the Constitution. And I mean, if we do not restrict the scope and the ambit of Section 128, we run the risk of having to change all statutes that can have a constitutional nature through Section 128. So, to alter the Statute for Westminster Adoption Act, we need to apply Section 128. To alter the Australia Act, we need to apply Section 128. But this is not how we do things. Section 128 exists only for the alteration of the text of the Constitution as occasionally amended and written in Section 9 of the Constitution Act. Its restricted operation is only within the limits of this Constitution of the Commonwealth. Okay, so if we can't create or amend the preamble using Section 128, and you nonetheless said it may be possible to create a preamble, how could it be done? Many scholars have answered these questions by reference to Section 5138 of the Constitution. In my last video, I explained this section, and I also showed how the Australia Act were the result of the processes expressed in that provision. Basically, Section 5138 says that the states can request the Commonwealth to legislate on their behalf on matters that only the Parliament of the UK could legislate for before federation. So the idea is that since the Parliament of the UK was the only one who could alter the Constitution Act, that power could now go to the Commonwealth Parliament under the request of all the Australian states, and the Commonwealth could then legislate in that respect, even if there are no express legislative powers given to it in the text of the Constitution. Of course, this power that is granted to the Commonwealth must be subjected to the Constitution nonetheless. There's a lot of discussion whether Section 5138 could be used to alter the covering clauses of the Constitution Act. Some covering clauses have an immediate effect in the Constitution, so changing them could amount to changing the Constitution, and that cannot happen under Section 5138 because its powers are subject to the Constitution, and because this would be indeed a breach of the determination in Section 128. But other covering clauses could apparently be changed without interfering with the dynamics of the Constitution. But I'm not here talking about these issues though. My point is only about the preamble. Can we use Section 5138 to alter or create a preamble? Alright, full disclosure here, I have gone back and forth with this one, trying to grapple with this question in thinking if there's anything in the Constitution that actually prevents the exercise of this power by the Commonwealth, and I don't think there is. I don't think there's anything in the Constitution that can avoid the Commonwealth from exercising this power to create or amend the preamble under Section 5138. Ultimately, the change or creation of a preamble does not affect the Constitution. So I am very much inclined to say that there is only this possibility under the Constitution that would allow the Commonwealth Parliament to amend or create a new preamble affecting the Constitution Act. It must be done through Section 5138. Now, let me be clear. First, I do not support the creation of a preamble outside the constitutional moment of the enactment of that constitution. This is my view independently of the proposed content of the preamble. I still think it might be doable in some countries, and if there's political will, fine. I just don't get it, and I advise against doing it. Overall, my opposition to this is based on the meta-constitutional nature of that preamble. Preamble is not constitutional, so I do not see any point in creating a new preamble whatsoever. The second thing is that I do not think the creation or amendment of the preamble to the Australian Constitution can happen through the process of Section 128. I know that this has been attempted before, but I have strong objections to it. If the preamble is meta-constitutional, that is, if it is outside the Constitution and cannot influence on the content of the Constitution, it is not possible to use the process of Section 128 to alter or create it. The initial words of Section 128 expressly refer to this Constitution, and there is a difference between the Constitutional Act, where the preamble is located, and the Australian Constitution per se. The preamble is not part of this Constitution, therefore cannot be altered under it. And finally, my last point is that if the preamble is to be created or amended, it can only happen either through a new constitution or under Section 5138 of this Constitution. Since the Australia Act 1986, the UK Parliament may not legislate for Australia anymore. So no possibility exists for the Commonwealth Parliament to request and consent to any alteration in the Constitution Act. But apparently, Section 5138 could potentially lead to an amendment of the Constitution Act by the Commonwealth Parliament if the states unanimously requested it to do so. I am of the view that this can happen, particularly because Section 5 of the Australia Act does not reserve the Constitution Act from the operation of its Section 1, that is, the repeal of Section 4 of the Statute of Westminster and the termination of all powers of the UK Parliament over the Commonwealth are not subjected to the text of the Constitution Act. The Constitution Act, therefore, can be changed. And there's nothing in Section 51 or elsewhere in the Constitution that delimits the scope of the legislative power of the Commonwealth with respect to the alteration of the covering clauses and the preamble of the Constitution Act. It cannot be done for Section 128, but it can apparently happen according to Section 5138. Of course, just because you can doesn't mean you should. And this will take me back to my first point. Even if creating a new preamble is legally sound and constitutionally permissible, I do not see the point. Other than of a strictly symbolic nature, I don't see any reason for creating or altering the preamble to the Australian Constitution. Well, I hope you enjoyed this video. If you did, don't forget to leave a like and click subscribe as well, because then you can join our Aussie Law community. I hope to see you again next time. Until then, ciao.